Hello and welcome to the Asian Society of International Law 101, a space where we discuss and debate new developments in international law in Asia and around the world.
Hello, everyone, and welcome to this webinar. We're really pleased to actually have you guys here. My name is Marcelo Diaz, and I have the privilege of serving as a co-chair of the Oceans and International Environmental Law Interest Group within ANZIL, the Australian and New Zealand Society of International Law. It's a real honor to welcome you to this joint and first AsianSIL webinar. First, a word of thanks. I want to warmly acknowledge my fellow OIELIG co-chairs, Joy Oliver, Margaret Young, and Louis Batista for their support and vision in shaping this conversation. I'm also equally grateful to our colleagues from the Asian Society of International Law's International Environmental Law Group, especially Emil and Mustafa, whose partnership has been essential in bringing us together today. Thank you as well for our panelists, Dr. Laodi Arif, Dr. Laili Nerdia, Dr. Stolina Judy, and Dr. Arif Malik for their time, energy, and deep expertise in the matter. And finally, my sincere thanks to all of you in the audience today. You are giving your time to engage with a topic that sits right at the intersection of international law, technology, and forest protection at the worldwide level. But today, the focus is the Australian Illegal Logging Prohibition Amendment, Strengthening Measures to Prevent Illegal Timber Trade Act 2024. At first sight, this might look like a technical update to a domestic statute. In reality, it's one more strand in a dense web of international norms and supply chain practice that determine whether the timber we trade is lawful, traceable, and compatible with a livable planet. The starting point of this conversation is simple, but can be a bit uncomfortable. Before Australia first introduced its illegal logging laws in 2012, the government estimated that around 10% of our annual timber and wood-based imports may have been illegally logged, undercutting legal producers and rewarding destructive practice overseas. At the same time, UN assessments indicated that up to roughly $700 million of Australian timber's imports each year were coming from high-risk sources. And illegality here is not only an offshore problem. The government itself acknowledges isolated cases of high-value Australian timber being illegally logged, while recent state-level prosecutions, such as some convictions in New South Wales, have shown how fragile legality can be, even here in Australia, in this area. The 2024 amendment responds to this reality. It does not change the core offense. Importing or processing illegally logged timber remains prohibited, but it modernized the machinery around it. It enables timber testing at the border and beyond. It also introduces advance notice obligations for importers and processors via a dedicated IT system. It strengthens due diligence and record-keeping duties and broadens the enforcement toolkit with strict liability offenses, civil penalties, audits, and public naming of serious non-compliance. From an international law perspective, this is not happening in a vacuum. Australia is adjusting its domestic bundling in a response to a wider shift. The EU's moved from the old timber regulation to the more demanding deforestation regulation. The long-standing do-care model under the US Lacey Act, Indonesia's SVLK, and flagged license system, as well as Japan's Clean Wood Act. Taken together, these regimes are rewriting the expectations that flow through global value chains. It is no longer acceptable to say, we didn't know where this wood came from. Therefore, states are increasingly using trade measures, disclosure duties, and risk-based controls as tools to advance environmental integrity, a quiet, practical evolution in international environmental law. But where does traceability fit into this story? The Australian legislation is formally technology neutral. It does not prescribe, for example, barcodes or blockchain in the black letter. What it does say is that it raises the evidentiary systems, gather consignment level information on species, origin and supply chain actors, verify certified claims, and keep those records for at least 5 years, subject to audit and potential testing. Once you look at those duties through a practical lens, the message is clear. Without traceability, you simply cannot comply with the law at scale. That's where technology, from electronic chain of custody systems and digital document repositories to remote sensing tools and DNA and species testing techniques becomes the nervous systems of legality. This is also a story about responsibility that travels with the product. By applying these rules to both imported timber and the processing of Australian grown logs, the Act recognizes that Australia's environmental obligations do not stop at the border. They extend upstream into foreign forests that supply our markets, and downstream into communities and ecosystems affected by how we manage our own forests. In that sense, the amendment is part of a broader shift in international environmental law, from aspirational commitments about sustainable forest management to operational rules that attach legal risks and legal incentives to the flow of wood through complex global chains. Before I hand over to our distinguished speakers today, a quick word on housekeeping for this webinar. Each panelist here will have around 10 minutes for their presentations. After all four interventions, we will move to 20-25 minutes of questions and answers. You're very welcome to post questions via the webinar in the chat as we go, and we will collect them for the discussions. If we run out of time and your question isn't addressed live, we will do our best to follow up with you afterwards by email, connecting you with the relevant speakers so the conversation can continue. And with that being said, and without further ado, I would like to hand over the word to Dr. Odi.
Thank you, Marcelo, and thank you all participants and panelists. I think, Marcelo, it is already explained about the importance of how to stop illegal logging. And I think the responsibility of the state, it is actually not stop at the border, but I think this is actually the responsibility for a lot of us. However, I think in my presentation, I will not only talking about like the technical aspect of illegal logging, but I think I'm going to be more broader than that because I see it. Illegal logging actually is different from like a drug. A drug you can actually hiding them, but illegal logging actually you cannot hiding them because it is actually a big operation. We just actually published a book by Forest People program last year, and I think I was actually commenting on this book. So I always see illegal logging. It is also related to the politics of the country. The illegal logging, it is illegal logging only as symptoms of political corruption and the interplay of politics, private sector, and black economy of the country. At least it is in Indonesia, but also in other country. Illegal logging is obvious. Everybody can actually see them and cannot be actually hide. But the law enforcement agency sometimes actually just closing their eyes because they want to do some kind of enforcement because they are entangled with the political situation of the country. This is actually a new one. So I thought illegal logging should be, because we've been actually talking about illegal logging in Indonesia since 70s. And now actually just last month, actually I just want to give you an example of this big operations in West Sumatra of Indonesia, for example. This is a big operation, actually, if you can actually check them. But before we are talking about the current situation, it is always important to look at the history of the country. Just you can see from this picture, for example, the interplay between a politics and forest and mining and fisheries. But let's talking about the forest today. For example, the previous presidents of Indonesia and Suharto, for example, actually going fishing with the tycoon of loggers, Indonesian loggers, for example. So that's the reality. This is, you can see from Suharto time until Joko Widodo, he just actually finished his terms. And you can actually see this. The same people, for example, the wedding of this Prayogo Pangestu, it is attended by like 4 presidents of Indonesia. The wedding of his daughter, for example. So you can actually see who actually roaming in the Indonesian forest. It is not always like illegal, but actually they are also taking timber and wood from illegal activities. And another one, for example, it is sustainable relation for unsustainable forest management, for example. They always with the president. They close to the president. So if you are, for example, talking about illegal logging in Papua New Guinea, then who is actually responsible? The government, no, but why actually they are not doing something? Just like in Indonesia. I mean, this is happening all over the world. So if you actually look at those, they are actually, they're all tigers. Some of them actually already passed away, but now they are actually establishing a big corporation just like Salim Group, Group Nusamba, Barito Pacific Group, Sinarmas Group. They are actually focusing on that. But in the past, they've been actually roaming Indonesian forest. And this is the minister. The Minister of Forestry at that time, during his terms, now he's become Ministry of Coordinating Ministry for Economy, for example. He is actually the one who gave a lot of license. And this is actually driving forest and land use change. So meaning that illegal logging or unsustainable practice of forest harvesting, it is always the link with the politics. So if you're actually interested, Jackie, a friend of mine from University of West Australia, for example, you can actually see network of forestry-related corruption, for example. And when I was Corruption Eradication Commission, 2015-2019, I also published this, for example, with Sophie, tackling forestry corruption in Indonesia. So, I mean, that's actually happening. And when I was a commissioner, I see it my own eyes. And that's why we are prosecuting several peoples. So if you look at, for example, this is actually the head of a district, just like a mayor level in Sumatra, for example. He actually corrupting by giving license to his family 8 companies. Try to establish wood processing, etc. So I mean, like, they are maybe legal, but actually illegal. But because they are corrupt, etc., etc. And I think I don't want to go, but actually this is an example of the governors, member of parliaments, or mayor, and even actually police officers involving in forestry-related corruption. Fortunately, some of them actually, when I was in KPK, I was prosecuting them. They got like 4 of them during my terms and the previous one. So meaning we do something to stop it. but it is not enough because always in every operation of illegal logging involving the police, the military peoples, and the politicians. So those are people. They are actually already, they've been actually served their jail terms. Like for example, this one with the boy, now he's actually causing up with the presidential chief of staff, for example. Now he is out of jail, but still actually have a friend in the government. And if you look at actually the member of Indonesian parliaments, 2019, 2024, for example, we have the total of 557, 75, and 262, most of them actually business people. So the entangle, and most of them are also in natural resources, some of them in forestry, in mining, and many others. And if you look at the current members of Indonesian Parliament 2024, 2029, for example, in the ruling party, for example, you 110 of them actually from business. Every political party actually they install business people in the parliament. So when I was in the KPK, I do feel, for example, we are focusing on natural resources corruptions, and of course we are supporting timber legality as a verification system with EU. We also created national movement to save Indonesian natural resources and just try to prevent corruption within the forest, and even actually beneficial ownership registration of those companies. And we are also assisting the Ministry of Environment and Forestry, for example, to establish called National Forest Monitoring System, an online information system of forest product management. This is actually a technology, and also it is actually assist. The technology can improve transparency and accountability, and have the potential to prevent corruptions if actually properly managed by the ministry itself. But again, it depends on the ministry. And also, we actually trying to address conflict of interest. So, I mean, if you want to address illegal logging, you need to have like conflict of interest regulation. And also, of course, electoral reform transparency. This has become actually wide, not technical, because always entangled with politics. If you cannot fix the political aspect, it is almost impossible to fix illegal logging, because illegal logging only has symptoms. The root cause is political corruption. And of course, the continuous scrutiny from the public and civil society, it is very, very important, and consistent enforcement and prosecution of every legal violation of natural resources right law, it is actually important. Unfortunately, because they are actually well connected, it is sometimes very difficult to have a big hope on the Indonesian National Police of the Ministry of Forestry, for example. To touch on international cooperation, I think Marcelo already actually mentioned briefly about the importance of LACI Act. For example, FLEGT and Australia Legal Prohibition Act and Japanese Clean Act would. Indonesia actually try to comply with those now. I mean, start from 5 or 10 years ago. We actually trying to comply with it. But unfortunately, some country like China and other countries are still open for illegal timber trade. And in a friend of ours, actually, for example, they use actually launders, traceability and complex international supply chain of tropical wood. For example, from PNG go directly to China, to Somalia, and China exporting those illegal laundering it and send it to German, to those countries. Vietnam do the same things, and many Indonesian timber actually go to the same road. So I think this is very, very important. Why this actually happening? This is because we do not actually want to eradicate illegal logging, but because the politic of the country actually is still corrupt. So therefore, I think it is also important. The conclusion is my conclusion. Illegal logging and other natural resources crimes are the sons and the daughters of government and private sector corruptions. And of course, it is the big governance problem. And I thank you very much. Thank you very much.
Thank you so much, Dr. Odi. We highly appreciate your very thoughtful presentation. And now, within that said, due to time constraints, I would like to hand it over to Dr. Estelina. Dr. Estelina, the word is with you.
Well, good morning to all of you. First of all, I thank Mustafa for giving me this opportunity, and also for Marcelo for setting the stage, and also Dr. Siarif for trying to contextualize the issue. So I will, in the next 10 minutes, try to flag certain concerns under international law, and also will try to bring the Indian perspective with regard to the traceability in the forest governance. So let me start with one of the very recent cases which is filed as a public interest litigation in India. So there was a public interest litigation filed in the area of Himachal Pradesh, and the subject matter of the public interest litigation was the plaintiff actually challenged a large-scale illegal felling. He also pointed out that this particular year itself, this was filed in 2022, so almost more than 600 times the forest officials has found out that there is an illegal, the vehicles and all has been caught. So this particular division is somewhere located in the different states' borders. So there is a lot of exit route. So that actually in a kind of promote strategically the illegal logging. So two observations from the court are very important. And I think that reiterates what Professor Dr. Siarif in his presentation has highlighted the corruption part. So the Himachal Pradesh High Court says that the problem of illegal logging is systemic and structural in nature, indicating the widespread, the failure of the forest governance and the corruptions which is prevailing. So I think that's something very, very important aspects to be governed. So the moment any discussion on the forest governance, that is also one sector where a large scale, massive corruption and the mafias that operates in many parts of the world. The second, the court also highlighted the significance of the GPS-based mapping, because that could be one of the solution to prevent or take action in terms of the illegal mining. So I think this is the first two starting point I wanted to highlight. All across the world, yes, the countries are taking different actions, but if you look at that there is an illegal logging, in terms of even the loss of its to the economy, and also how does it affect the environmental issues, the biodiversity loss, or perhaps even resulting in the greenhouse gas emissions. So these are all very, very well established in terms of whatever the consequences. But I want to actually highlight two facts. One, when you look at the international legal framework, yes, we do have a patchwork of international legal governance in a fragmented sense governing the forest. But none of this governance structure actually looks at forest on its own per se, the need to protect. The idea of looking at nature from a very, very political and economical construct, where the nature has to be used as a resource. So even the idea of the timber trade, the prevention of illegal logging, I think this comes essentially from a point of a state interest that the state sovereignty is threatened. It is distorting international trade. So the state is losing millions. But the discourse is not centered around what is its impact on community, the indigenous people who is looked at it, or from a nature-centric per se point of view. So I think That is also one of the point to flag. How do we even look at the international legal framework from what is the right perspective through, or the lens through which we should actually look at the international governance? But nevertheless, illegal logging is definitely a result of the governance failure, despite a lack of the legal framework. So one of the solution to prosecute at least or prevent the illegal logging is the traceability part. So when you analyze the traceability, I believe we have definitely developed a lot of technological tools in that. But the question is that if we have the technological tools, like, is it really reflected in the legal framework, and what is the challenge in terms of implementation? So I believe one of the challenge in terms of the traceability at the international level is, it's an interesting analogy. When you look at the also climate change or biodiversity, all other environmental legal issues, we do have one, at least a major conventions which is governing. But this is one area where the international community, despite knowing the relevance of it in terms of environmental law protection or the climate change regulation, forest is an area where we don't have a comprehensive international guidelines. So there is a patchwork. So you have CITES Convention, which talks about preventing or regulating the trade in wild flora and fauna. You have the Convention on Biological Diversity, focusing on sustainable management. And in this actually mix, you can even talk about the UNFCCC mechanism and the RED mechanism, where the forest is involved in it. You can also maybe bring in the United Nations organized transnational, the Convention on Organized Transnational Crime, where illegal logging can also be brought in. So you have a patchwork of fragmented legal regime. I believe that also affects how do you look at from the definition to the entire management of the forest. So what is exactly the challenge in terms of it? So, and in terms of legal analogy, the CITES could be the most relevant international regulations we look when we talk about the trade and the illegal logging and the traceability aspects. But if you look at the CITES, yes, they do provide a workable definition in terms of the traceability. They mandate the legal certainty, and also to see that the trade is not detrimental to the species, so the non-detrimental findings. So in a way, it ensures the legal certainty and sustainability aspects. But the CITES overall doesn't exactly provide a very, very clear-cut, the globally applicable rules for every country in terms of it. And to top it, the CITES doesn't cover the timber category. It has a very specific, it has the appendix. So in terms of the scope and coverage itself, it becomes actually the problematic. And the additional fact is that CITES is not really intent to bring the traceability or prevent, but it is to rather regulate. So even if somebody is having an export or a re-export permit under the CITES, that doesn't really mean that the traceability and the supply chain, the mechanism is already has been actually verified. So the CITES, like many of the international convention, gives a lot of flexibility to the countries. So you have on the other side, maybe the European Union, in terms of the import, has come out with a very stringent sustainability regulation. Or you have now the countries like Ghana or Indonesia has come out with, from a production side or export side countries, with guidelines. But you have countries like India or the Myanmar or Malaysia. There are many countries where the regulations has not been very proactive or robust. So the point is that, yes, it has been left to the countries in terms of national implementation. So this is the same kind of a story, even when you look at, let's say, convention like the CBD also, which gives the countries a whole lot of flexibility in terms of taking appropriate measures. The language of the convention itself gives that kind of flexibility. So in this matter of the flexibility, I want to highlight two aspects. One, definitely, I think this is often a debate which is normally there in international environmental or a trade framework, there is a technological divide which definitely exists there. The global north, many of the countries do have the technological and infrastructure capability to implement a whole, because the traceability is more about a lot of the technical tools, whether it is the DNA aspects or the GPS or a barcode or a blockchain, whatever you're talking about. So many countries do not have the technical ability and also to implement that part. So when countries like the European Union comes out with strict regulations, which may not be able to be easily fulfilled by the many countries in the global south, that also leads to a kind of market exclusion, right? So that also has to create one has to understand that it is in a way forcing the global south country to have face the burden of the technological, how do I put it? The duty to implement these when they are lacking the technological ability, right? But this is only one side of the story. This is not to say that the global south countries do not have a responsibility. No, they, as Professor Siarf has definitely pointed out in his presentation, this is also a sector in the global south countries. There is a governance failure or a corruption issues. So in this aspect, justice gap is very important. So in this entire the discourse on the trade, we somewhere forgets the indigenous people and the smallholders. Like, okay, what is their role? Can they be a party in terms of bring implementation of the traceability? It could be a physical verifiability, but yes, they are a major stakeholder. So so these are the two aspects which I feel in terms of the implementation gap. One is the global north and south, the technical one. The second one is more systemic, which is the participation and the justice aspect. How do you even look at the entire forest governance, that narrative part? So with this background, let me just shift to India. So when I look at India, what I see is we have a very, very extensive forest governance with multiple legislations governing it. But this is also an area similar to Indonesia where the transparency aspect is really missing. So you can say that, yes, the corruption and the governance failure, the Forest Department, India is notorious for the corruption activity. But since India is a quasi-federal, there are certain legal structural issues also comes in the context of forest governance. So as part of the legislative structure, the forest falls under, like in India, there are three categories of legislative list. In some category, it is only the central government can legislate and in some other state. But forest actually comes under the concurrent where both state and the center can regulate. But the interstate trade is actually part of the state. So essentially what is that? It's a patchwork where the different states has come out with different regulations. For instance, maybe one state may say that felling of trees in a private plantation has to be given, the license has to be there, but in other state it may not be there. So it may be justified in the context of the constitutional framework, but I think that creates an overlapping with different state has a different kind of an approach with regard to the traceability issues. Though the Ministry of Environment and State and Forest actually tries to regulate the sites aspects. So it's only very recently that India has actually come out with some sort of guidelines relating to the traceability.
I just have 1 minute to make a conclusion.
Yes, I'll just wind up. So two aspects I wanted to highlight. India is not actually a very major global exporter of raw timber, but we are a largest importer of raw timber and also the exporter of reprocessed one. So what we face is, so we don't look at in a larger scale, the issue of a traceability more as part of an international obligation. It's more of an domestic administrative burden. But this doesn't mean that India is not faced with the issues of the illegal, the timber trade and the issue of a traceability. We have a lot of illegal logging that comes from the Myanmar border. Like once the goods are processed, even the sites also cannot be even the tracked. So, so India does faces the problem in terms of the decentralized different state has an approach and having a lack of a nationally accepted the traceability rule. But we do have certain kind of a best practices which is developed, community-based practice, and various state governments are now insisting on a centralized timber management system. But what I wanted to highlight is what is the way forward. I believe international trade law is an entry point, and that's where the business interest resides. So if the WTO structure can include that whenever these timbers are part of this, the international trade, they mandatory the traceability. I think that can actually reduce a whole lot of things, but I do not know how, whether how that particular challenge, because WTO may say that that's not under our purview, it's on that. But so, but I also want to highlight the process. Yarif's presentation was really on the point. So this also does mean that any kind of a governance reforms has to protect the whistleblowers and the human rights defenders, highlighting the need of political will. So I'm so sorry for exceeding the time. So I'll just stop.
No, thank you, Dr. Sterling. I've drawn a powerful picture of fragmented legal landscape, corruption in India, and the flexibility and patchiness of the international legal framework. And with that being said, now you have the floor, Dr. Lali, for your presentation. 10 minutes, please. Thank you so kindly.
Good morning, everyone. First of all, I would like to thanks Mustafa for inviting me to speak in this webinar, and also Marcelo. Today, I would like to talk about how Indonesia moving towards sustainable forest management in Indonesia. Based on the previous speaker, Pak Laude, it seems like hopeless for Indonesia to have like a sustainable forest management in Indonesia with the rampant corruption at the political level or elite level. So today I would like to share the ground experience, my research at Rio, Meranti Island, which is there's so many rampant illegal logging also, but it is conducted by the local community. So first of all, we know that Indonesia becoming a key timber supplier for legal world market due to the abundance of forest resources. However, there's a growing demand and failing supply and inadequate law enforcement management have led Indonesia become a major source of illegal produce and export timber. However, Indonesia also committed to implementing sustainable forest management to follow Net Sink 2030, which aim to make the forestry and other land use sector net carbon sink 2030. However, actually the deforestation still high, which reach like 10.8 million hectares in various forest function. This is due to planned deforestation and also unplanned deforestation. Planned deforestation is caused by for example, converting legal conversion to natural forest to non-forest for oil palm plantation, also for food estate. Unplanned deforestation, including like forest encroachment and also natural disaster such as fire. With the increasing global market becoming increasingly selective with buyer and also consumer demanding sustainability and legality with the AUTR and Australia Illegal Logging Prohibition Amendment Act, actually Indonesia tried to comply to this, like with the AUDR requires timber and timber products sold with the legality harvested, and also with Australia tighten control illegal timber entering Australia. So actually, Indonesia timber industry must improve traceability and compliance to avoid trade barrier, and this requires implementing robust due diligence to prove timber legality potential, using new technology to verify origin, and adapting to supply chains to more strict market access requirement. So, how does Indonesia comply to that? Indonesia actually have a forest certification, which is it's already applied. Indonesia implemented mandatory market-based instrument with SPLK. This SPLK actually started in 2009, and also to implement sustainable forest management, as well as to implement good forestry governance and eradicate illegal logging and trade. The key requirement to include this verifying legality of the origin, harvest, transport, processing, complying with environmental and social standard, and companies must obtain SPLK certification from accredited independent agency such as Forest Stewardship Council or FSC. So in the implementation of the SPLK, actually there's so many challenges for the implementation. The current challenge is Indonesia plan to make a deregulation. The Ministry of Trade and coordinating Ministry of Economic Affairs actually plan to deregulate 441 HS code in the forestry sector, including making fee legal document optional for market outside EU and UK, and revoking the requirement to due diligence and import declaration for wood product. This proposal is actually a frame as a response to the US tariff and effort to increase export competitiveness. Another fundamental challenge in adoption of the SPLK is for small medium enterprise. In many of these companies, small medium enterprise, actually they do not meet the basic requirement for business legality. In addition, the slow process of legal verification is also influenced by high certification costs. So the certification cost for to get this FSC is costly, very high for a smallholder enterprise. In addition, legality and sustainability compliance was higher in value chain dominated by large-scale actor. So actually, for the companies, like they don't really like they comply to this SPLK. The illegality actually high level of illegality in a small scale sector. The high level of illegal logging and processing activities is caused by several factors. Some of these related to the lack of knowledge of the small medium enterprise regarding the official procedure, and also it is regarding to the livelihood. There's no other option for the community, and also high demand of wood supply. In addition, there's a problem of fragmented wood traceability system, inadequate independent monitoring, and also ineffective compliance mechanism and small scale sector. I will share the case study in Rio, the Meranti Island, in case study in Lukun, forest village. Like Palaude mentioned that there's many illegal logging, which is obvious, but the police and also the law enforcement does not really seriously handle these cases. Many of local communities, their livelihood is cutting the wood in the forest. Like it is their livelihood, and when the government introduce the alternative livelihood, they cannot replace it with the other, like more money. I mean, with the cutting the wood, they can get more money, but other alternative livelihood introduced by the government is not really giving them so much money. So therefore, like in this area also, there's many mangrove trees cut for charcoal, and they sell to the Singapore or also to the Malaysia. Like this is in the border of Malaysia and Singapore. So there's many like illegal logging of this mangrove cutting become charcoal, like in the picture, showing in the picture. So regarding the traceability, actually the timber traceability is the main element of SPLK. However, there is many challenge for this traceability in Indonesia. For example, the smallholder land legality. Many smallholder farmers still do not have a formal land certificate, which are the key requirement under the AUDR. The traceability is hindered by overlapping land claims because overlapping land claims create lack clarity in land ownership. Like in Indonesia, there's so many overlapping claim, like reported by the Ministry of Environment and Forestry. It is estimated 17.6 million to 25 million hectares of forest have conflict in the form of overlapping state claim between the government and also the indigenous people with the. So actually we have one map policy also, but this one map policy faces many socio-political, technical administration challenge. The challenge is how to recognize the indigenous customary forest. This is not yet clear in Indonesia because to recognize customary forest, it needs like the local government to recognize that under the local regulation. And regarding the DNA technology, actually there are many cases like logging conducted outside the designated area, illegal trading with the export document and falsification transport document. Actually, we already have implemented such a technology, but this because of limited equipment, human resources, and lack of adequate laboratories, it needs more cross-sectoral collaboration to expanding this implementation of the technology. So for the conclusion, actually, Indonesia is committed to implementing sustainable forest management. However, challenges remain at the ground level. There are many still illegal logging cases occur in the remote areas, and forest certification also limited to the small scale sector. So it needs like probably the group certification to reduce cost for the small holder and provide technical assistance like training and group organization leverage technology for monitoring. Moreover, the implementation of technology still face many challenges. So Indonesia need to have more cross-sectoral collaboration to use this technology. So I think that's my presentation. Thank
Thank
you.
you, Dr. Laili, for showcasing with us so honestly Indonesia big picture with regards to traceability and deforestation. And now, with that being said, I would like to hand over to our last panelist, Dr. Arif Malik. Dr. Arif, welcome, and well, you have the floor.
Thank you for the introduction, and thank you for inviting me to speak to you all today about the timber tracking we do here at the University of Adelaide. I was given a long list of things to talk about, so I'm going to jump straight in. So I'm the lab manager at the Advanced DNA Identification and Forensic Facility at the University of Adelaide. We research a wide variety of topics from conservation, genetics, restoration, ecology, and timber tracking. Timber tracking is our main focus, and that's why I'm here talking to you today. We develop testing that can be used for species identification, geographic origin verification, and in some instances, even individualization. So that's tracing an individual log or product through a supply chain back to its stump of origin. Much more difficult, but it is possible. We also do non-genetic testing, so we can do stable isotope ratio analysis and trace elemental analysis. This can produce a unique fingerprint to a specific growing area and can also help with provenancing. We are a member of the World Forest ID Consortium. So World Forest ID, for those who aren't familiar, have the goal of producing the world's largest geo-referenced collection of timber and forest products, so we can generate data and use this reference database for provenancing purposes. And that's just a nice picture of one of our labs, because I like showing them off. They're nice labs to work in. Now, it's really good having these tests available to us, but they're only as good as the reference databases supporting them. So when we're doing genetic testing for species identification, we tap into the GenBank reference database, which is free. It's online. It doesn't just contain timber and plant material sequences. It contains everything you can think of. But where there are gaps, we have to produce our own reference databases. So we've got our own in-house reference databases for species ID. When it comes to geographic origin testing, that's just in-house reference databases we rely on. That's the most time-consuming, expensive part of what we do, because we have to send people out into the field, collect samples, ship them back to Adelaide, and then produce the scientific data. For the non-genetic reference database, as I said, we're a member of World Forest ID, so we can tap into that fantastic resource. When it comes to DNA testing or sampling for DNA testing, we can analyze samples at any point in the supply chain, from harvest through to the end user and anywhere in between. Ideally, the samples we work with are freshly cut, untreated sapwood, but we rarely ever get that. The more processed a timber product is, the more degraded the DNA is, the more difficult it makes our life in the lab. But we have ways of dealing with that as well. Generally, we say it takes around 2 months to do our testing, with expedited options available, but it depends on what's being asked of us. We have catered to government, industry, and even individuals wanting to identify the floorboards in their houses, so we can operate on a large scale or a small scale. Generally, we say around 200 to 500 Australian dollars per sample. But again, that depends on how many samples we're given and the complexity of the analysis. Regardless, we always sit down with our clients first. We work out precisely what they want, and we come up with an appropriate cost. We don't do this to make money. We do this because we want to see our research being implemented. So we try to keep the cost down as best we can. So how reliable is our testing? Well, if we're doing DNA barcoding for species identification, we'll amplify a region of DNA, like this jumble of letters here, and we'll compare it with the reference database, so GenBank in this instance, and we'll see what the top hits are. Here we can see there's a 100% match to Tectona grandis for these 7 samples, and sure enough, that barcode was from teak, Tectona grandis. We can see that the similarity starts to drop as it starts matching to species that are not the true species of origin. Sometimes this might only be good enough to get us to genus level, depending on what we're looking at, but sometimes that's good enough to answer the question that's being asked of us. Like, is it a rosewood? Is it a pine? That's still sufficient to do that. It's much more complex when we do genotyping for our geographic origin verification. So we have to go out into the field, collect samples from multiple different populations, identify those unique genetic markers that can pinpoint the different populations. We also, once we have identified the markers, we mass screen samples. We do maybe 10% duplication of samples. The reproducibility testing is really important to show that we're getting the same results every time we do that analysis. For example, this is a set of markers I've developed recently for a timber species in Africa. We identified 60 markers that could distinguish between 3 different forest concessions. And when we did the reproducibility testing, we found there was an error rate of 0.16%, so minuscule. Even if that error did pop up occasionally, the results would not change. It would still be able to tell us what we need to know. The accuracy of the testing, it depends on what set of markers we're looking at, what species, and what level of assignment we're looking at. Is it continental level, country level, or concession level? In this instance, with this species from Africa, it worked really well. It was a 99.6% accuracy when we did our assignment back to population level. So I was very happy with that. But the reason I'm telling you all of this is because we've shown that the sequencing itself, really reliable, the accuracy of the test also really reliable. So it's exactly the kind of test you want. When it comes to criminal cases, we ask for samples to be witnessed during the collection, stored in tamper-proof bags before they're sent to us with a chain of custody form. So we can sign that when they arrive and we can forward that back on to the sender. When it isn't a criminal case, when it's just routine testing, the tamper-proof bags and the witness aren't required, but yeah, a courier or Australia Post, that's what we use in Australia, is sufficient to get the samples to us. When the samples do arrive to our lab, they are very secure. They are behind 3 swipe card access doors secured in our lab, and I'm the one that grants people access to our swipe card system. So no one's tampering with those samples once they arrive. All of our lab analyses are documented in our lab books. The data's backed up in university systems. So if we have to go back to that data later on, we know that it's going to be there, and it's a reliable system for us. We have standardized lab reports and court reports. So if we need to present this as evidence, we've got a standardized template that's easy to read and has been through the system before. I was asked to present a case study to you all. So this is a nice Australian one. Well, not really nice. We don't really want illegal logging to be happening anywhere, but so Australian sandalwood, Santalum spicatum, really threatened species. It's been over-harvested for over 100 years now, I think. There are different penalties depending on which state the crime occurs in. So criminals are regularly hopping between states to try and avoid penalties. So in this case, there was an individual who had 10.5 tons of this timber on his property in South Australia, with a value of around $250,000, and that was estimated to be around 300 to 400 trees that had been cut down. So compliance officers came to us. They wanted to verify the species. They wanted to verify had it come from South Australia or Western Australia. We have genetic markers that can be used for both. So our first set of markers can distinguish between 7 different species of Santalum. We analyzed the client samples, compared them to our reference data, and we had a 100% match to Australian sandalwood. We used our second set of markers to determine had the samples come from South Australia or Western Australia, and again, 100% match to South Australia. This individual was convicted under the National Parks and Wildlife Act for the illegal possession of timber, and our DNA evidence helped support that. Stable isotope analysis was also performed by researchers at the University of Adelaide, but we weren't involved in that. But the 2 methods complement each other really well, and there was a good outcome here. I think it's pretty obvious why this testing is useful. Sometimes paperwork can let us down. It can contain fraudulent information. DNA does not lie. It helps our clients show their due diligence requirements for Australian law and EUDR. It helps protect them, and it can help identify misdeclared timber early so we can do something about it. And all of this helps build the trust and protects the brands of these companies that we're working with. The testing we do, I've already shown you, it's very accurate, it's very reliable, and we have fantastic reference databases to support us. And yeah, if anyone has any questions or wants some testing done, we're always here to have a chat, so please do reach out. Thank you very much for listening.
Thank you very much, Dr. Laori, Dr. Lally, Dr. Stelina, and Dr. Ayer for those very rich and wonderful presentations. I think what we just heard forms a very coherent arc. We just start with the political economy of illegal logging and corruption, and how power and corporate influence shape that happens in forest. We then just move to the legal landscape, the patchwork across sites, climate law and domestic regimes, and the need for a more coherent traceability vision. We also heard very clearly the implementation challenges on the ground in Indonesia. And all of this connects directly to the question raised by the new Australian legislation and international law. I now would like to open the floor, but please feel free to post your questions in the chat or use the raise hand function, and we'll work through as many as we can in the time we have.
Marcelo, I'm happy to jump in and ask a question,
Thank you.
if you allow.
Of course.
Okay. Yeah, thank you. There's 4 presenters. So our wonderful presentations, quite balanced, and we got case studies from Indonesia, India, and also Australian perspectives. Great. And also Professor Jolie, that for sharing the international law perspectives. Thank you so much. So I take this opportunity to ask questions first, Professor Jolie, that I liked your idea that what you said, that our approach to this so-called timber trading or illegal logging, it's most anthropocentric rather than ecocentric or nature-centric. Thus, I really like that idea. So my question to you, that I understand that these illegal timber flows often cross multiple jurisdictions. So international law actually applies here. So precisely my question is actually, what practical steps or approach can be taken to improve this international cooperation among these custom authorities, environmental agencies, and private sector actors? And in your presentation, you highlighted the fragmented approach. So, and we understand that it needs more integrated approach to this. All relevant agencies like customs, environmental agencies, even the communities and private sectors, businesses, they must work together for sustainable forest management. So that's one.
Thank you, Mustafa. I believe it's a very complicated question that you have asked. I don't know whether I do have a black and white answer to it. See, first starting with the ecocentric approach, I think that's more of a discourse narrative. So that definitely fundamentally the international law may have to look at not just from a third world approach, but the emerging fourth world approach and the ecocentric. So that's, I suppose, that's a long way to go. Even with regard to how to promote that international collaboration, I think it's a very, very challenging area, given the fact that you have, even in terms of forest domestically, multiple players from some of the states own the entire forest reserve, but you also have private plantations, you also have agroforestry. So there are, from the state to private sectors to the indigenous communities. And then, okay, you have the trade dimensions where the customs and other forest officials, all that. But what I feel is that in this particular fragmented legal regime, there are other, like if I take the CBT and Nagoya Protocol, even the benefit sharing, we do have some kind of a structure with some kind of the checkpoints where. But this is an area where there is not much of a checkpoints which is developed, and that could be due to the lack of a comprehensive international the forest governance. But right now it is a combination of voluntary, soft, the hard law binding. See, one method to bring collaboration is definitely, I believe it may not be a very practical, challenging, that is at the trade level, because all this illegal logging, ultimately it becomes part of, or they at least aim to become part of the international trade. So the essential checkpoint or the most effective checkpoints, I think it starts with the WTO framework. But that WTO framework may not be very, appreciative of this if you go by even the IPR regime of the Nagoya Protocol, where the disclosure of origin, the developing countries have been arguing at the WTO for sometimes that has been now negated. So I believe that's the most effective checkpoints at the WTO level, because that's where it hits corporate the interest. Thank you.
My question is to Dr. Laili, that who you highlighted in your presentations about the indigenous communities, the aspects of involvement of the indigenous communities and indigenous rights. So my question is that how do traceability frameworks and international timber regulations actually account for the rights and knowledge of indigenous communities? And how can these systems avoid creating new burdens on them while still combating illegal logging? So that's the thing.
Thank you, Mustafa, for the question. Actually, with the indigenous community, with this international regulation, actually, some of them, like, for example, some of the companies actually can enclave their territory. Jadi, so they make it outside of the illegal, their concession. So with this recognition that the area is indigenous people, so it's outside of the concession, because some of concession are overlapping with the indigenous community territory. So to comply with traceability, the companies actually make it recognize this indigenous people territory, so they can, like, not really violating the human rights, like indigenous land. I mean, and this is their land, so the concession should comply with the traceability, that is they not violating the indigenous right, something like that. So I think it is not really creating a new burden, but it's actually with this they recognize the indigenous people territory. So the thing is, Indonesia is need to improve the recognition of this indigenous community land or territory or forest. Currently, Prabowo administration actually plan to release, I don't know how many, to 17 million, or they committed to release of this indigenous forest to the indigenous community in Indonesia. So I think it's a good way progress to recognition of indigenous people forest land.
I just to add a little bit about actually from Lily. I think in order to understand the illegality of a timber in every country, you have actually to check also national law in every country. For example, in Indonesia, if you have a concessions, for example, 10 hectares, some of them actually, if you are actually harvesting within the 10 hectares of your concession, it is actually legal. But some of them actually, they are harvesting outside their concessions, which is actually considered illegal. Or because based on the Indonesian law, you can actually harvest within your own concession, but we call it selected cutting. You can be cut like a mature forest with actually the planning. So if you are not following that, that means actually also illegal. So I mean, this is very, very important to understand the nuance of every country. Number three, it is also important to see the role of international law, for example, or special requirement of special jurisdiction. For example, I was involved in the negotiation with the EU during timber legality assurance system, for example. So the legality actually drive from the importance of the legality from within Indonesia actually drive by international community. Unfortunately, some biggest country that actually the importance of many timber, like China, for example, they do not have that. So meaning they can always laundering the money, so that we actually Arif can actually play a role whether this particular wood actually coming from Indonesia or really from China. But again, many of them not as trying to be very realistic. We all know actually international aspect of it, but in reality, it is usually they just close their eyes because they need the timber. And as I mentioned, I mean, illegal timber or illegal logging, it is not easy to cover it up because you can actually big scale. So if a corruption still rampant, then I mean, it is very difficult. I mean, just being realistic. And thank you.
And quickly, I like to ask Dr. Arif Malik that, uh, and I loved your presentation, the important work you do, the science-based works and studies that actually that help preventing illegal timber trading. So just I like to ask your insight that beyond penalties, and you ask about the criminal aspects, the beyond penalties, to what do you think that to what extent can market-based mechanisms such as sustainability certifications or say carbon credit schemes actually drive compliance and support legal timber trade?
Yeah, I obviously gave a case study of where someone was penalized for doing the wrong thing, but you hit the nail on the head. I really hope that our testing can protect people more than punish people, and people do want to see this sustainable harvest of timber. So I'm hoping that the market does change the way people think, and they will start looking for those sustainable products, and our testing won't be used just for penalizing people. It'll be used to encourage people to do the right thing. So yeah, you've hit the nail on the head there.
There is a question for Eric from Margaret Young. Margaret is asking you, Eric, if you in your lab, your type of testing be also used in other items that are prone to illegal trade or overproductions like fisheries or endangered species?
Yeah, we have researchers that work in the seafood and wildlife crime space. So yeah, that testing is definitely applicable, and we're developing new tests all the time.
Well, that's wonderful. Well, I think that we're getting to our final hour. I would like to congratulate everybody for the wonderful presentations and everybody who joined us here. I also would like to say that I sincerely thank each of you for your time, your questions, and of course, your commitment to strengthening the legality and integrity of the global timber trade. There are many questions that I would like, as a researcher in this area, to posit for you, but unfortunately, time does not allow. But your presence and engagement here with us today show that these issues matter well beyond any single statute or jurisdiction. Thank you so kindly for everyone who joined us, and I feel really pleased to have had the chance to chair this webinar. Thank you again. All the very best.
Thank you for joining us at the Asian Society of International Law 101, and watch the space for future conversations.